So, good morning to all of you. I hope I'm audible and visible to all of you. So, let's start today's discussion. Now, today we are planning to discuss 2018 question paper, in which we are going to discuss 2018 shift 1 question paper, in which today we are planning to discuss transfer of property act, some of the questions from Indian Contract Act. Then we are going to discuss some of the question from MP local laws, that is MP Accommodation Control Act, and then MP Land Revenue Code. So if you people haven't subscribed to the channel till now, please go and subscribe, and don't forget to press the bell icon. So whenever me or any of the faculties are coming live, you people will get the notification. And if you people haven't checked out till now MP Civil Judge Prelims crash course, link is in the description box, in which you are getting 10 plus mocks, one-on-one mentoring and doubt clearing sessions, and much more. So don't forget to check it out. Now let's start today's discussion. The first question is Transfer of Property Act. This is like question number 31. This is stating that the doctrine of lis pendens is explained in the famous case of. The doctrine of lis pendens means during the pendency of a suit, a particular property cannot be transferred. So the doctrine of lis pendens is explained in the famous case of option A, Musahur Sahu versus Hakim Lal. Option B, Muhammad Shafi versus Muhammad Sayyid. Option C, Tulk versus Moxhay. 31 ka D, Vinny ji is saying 31 ka D. Okay, and the D option is Bellamy versus Sabine. So its correct answer is yes, Vinny ji, you are correct. 31 ka D will be the correct answer, that is Bellamy versus Sabine. Question number 32. Under the Transfer of Property Act, if the owner dies before the acceptance of the gift by the donee. So this particular question is from the gift wala chapter of Transfer of Property Act. So the gift will be valid. Option B, gift will be void. Option C, the gift is voidable. And D, none of these. So under Transfer of Property Act, if the donor dies before the acceptance of the gift by the donee, the gift is valid, the gift is void, the gift is voidable, and none of these. Question number 32. What should be the correct answer? Yes. Now, its correct answer will be that the gift is void. The gift is void. Yes, Ujjwal Naharji, Vinny ji, both of you are correct. If you will follow up section 122 of Transfer of Property Act, there you can find that the gift is void. Question number 33. This question is from Indian Contract Act. Which contract is specifically enforceable? Option A, contract by B to deliver a lecture of law at Jabalpur University. Option B, contract of marriage. Option C, contract by B with A to supply goods as of when A requires, and D, none of these. Which of the following contract is specifically enforceable? Option A, contract by B to deliver a lecture of law at Jaipur University. Option B, contract of marriage. Option C, contract by B with A to supply of goods as when A requires, and D, none of these. Yeah, none of the above. So 33, what should be the correct answer? Yes. Now, if we will follow question number 33, its correct answer should be none of the above, right? But some of you might get confusion with option B as well, right? If you will see the contract of specific enforceability, yes, this particular question was disputed. So at last, MP High Court considered both of these options correct, option C and D, right? Now, moving further, question number 34. Inadequacy of consideration is relevant in determining the question of. Inadequacy of consideration is relevant in determining the question of. Option A, fraud. Option B, misrepresentation. Option C, undue influence. And option D, free consent. Inadequacy of consideration is relevant in determining the question of fraud, misrepresentation, undue influence, and free consent. What should be the correct answer of question number 34? Yes. Can anyone tell me what should be the correct answer? Yes, its correct answer will be D for Delhi. That is free consent. Now remember that fraud, misrepresentation, undue influence, all these are the parameters to judge whether the consent was free or not. So its correct answer will be D for Delhi, that is free consent. Question number 35. If only, yes, Ujjwal Nahar ji, Vinny ji, both of you are correct. Now, question number 35. If only a part of the consideration or object is unlawful, the contract under section 24 of Indian Contract Act shall be option A, void to the extent the same are lawful, B, void, valid to the extent the same are unlawful, option C, void as a whole, and option D, valid as a whole. Question number 35. Where the object or the consideration is unlawful behind the contract as per section 24, valid to the extent the same are lawful, valid to the extent the same are unlawful, and void as a whole and valid as a whole. What should be the correct answer of question number 35? Yes, its correct answer will be B for C for Calcutta, that is void as a whole. Void as a whole. Yes, Ujjwal Nahar ji, you are correct. Vinny ji, its answer will not be A. Now, some of you might get confused between A and C. So let me tell you, where one branch of a particular contract is legal and another branch is illegal, then in that case, it is valid to the extent the same are lawful. So it cannot be A answer. Its correct answer will be C. Question number 36. What 36 is saying? Two parties entered into a contract. They later realized that there was a mistake in their understanding of law as applicable in India. This mistake to their contract is A, non-est, B, void, C, voidable, D, not voidable. What should be the correct answer of question number 36? When two parties enter into a contract, they later realized that there was a mistake in their understanding of law as applicable in India. So what will be the effect of this? How the contract will be executed in that case? Non-est, void, voidable, not voidable. Its correct answer will be not voidable. 36 ka D is the correct answer. Now, if you will read section 21 of Indian Contract Act, it simply states that when two parties does not understand that the particular law is applicable in India, so its effect will be the same as of mistake of fact. So it will become not voidable, right? Nahi, Ankita Gupta ji, Vinny ji, Ujjwal Nahar ji, its correct answer will be D, that is not voidable, right? Next question, question number 37. Frustration of contract is provided in which section of Indian Contract Act? Frustration of contract is provided by which section of Indian Contract Act? Option A 70, option B 2D, option C 56, and option D 73. Frustration of contract is provided by which section of Indian Contract Act? 70, 2D, 56 and 73. What should be the correct answer with question number 37? Yes, it is quite easy question, repetitive question. Frustration of contract or doctrine of supervening impossibility, all these principles are inculcated. Yes, Vinny ji, you are correct. 37 ka C is the right answer, that is under section 56. Next question, question number 38, that is goods displays. Here the word is not gods, it's goods, right? Goods displayed in the showcase of a shop with a price tag is option A invitation to offer, option B counter offer, option C communication, and option D none of these. Yes, Ujjwal Nahar ji, Ankita ji, all of you are correct. Okay, so under Indian Contract Act, goods displayed in showcase of a shop with a price tag is option A invitation to offer, option B counter offer, option C communication, option D none of these. Yes, Vinny ji, Ujjwal Nahar ji, all of you are correct. Its correct answer will be invitation to offer. Now, next question is question number 39. A enters into a contract with B to sell him 100 bales of cotton and afterward discovers that B was acting as agent for C. For the price of the cotton, A may sue. Option A only against C, option B only against B, option C against B or C or both, and D neither against A nor B. Question number 39. What should be the correct answer? Question number 39. A enters into a contract with B to sell him 100 bales of cottons, and afterwards discovers that B was acting as an agent for C. For the price of the cotton, A may sue only against C, only against B or C or both, neither B nor C. What should be the correct answer? Question number 39. Yes, its correct answer will be C for Calcutta. That is against B or C or both. Yes, Viniji, you are right. Next question, question number 40. Under Indian Contract Act, when does an agreement becomes a contract? Yes, Ujjwal Nahar ji, you are also correct. Its answer will be C. Ankita Gupta ji, no, 39 ka it will not be A. Its correct answer will be C. Right? Question number 40. Under Indian Contract Act, when does an agreement becomes a contract? Option A, when it is enforceable by law. Option B, it is between parties competent to contract. Option C, it is by the free consent of the parties. And option D, all of the above. Yeah, all of these. Right. Question number 40. What should be the correct answer? Now, before you people answer question number 40, let me tell you this question was disputed. Yes, Ujjwal Nahar ji, D is the correct answer. But at the same time, if someone is marking A, he is also correct. The reason behind is, if you will read the definition clause, that is section 2H of Indian Contract Act, it simply means an agreement enforceable by law is a contract. So that can also be a probable answer. And at the same time, if you will read section 10 of Indian Contract Act, so all of these are essential conditions. So D can also be the correct answer. Question number 41. Right? Yes, A also. Bilkul, Ujjwal Nahar ji. Question number 41. This question is from Specific Relief Act. What the question is saying, where in any suit for specific performance of contract or any part thereof is dismissed, then the suit for breach of compensation is, option A, is barred, B, instituted with the permission of court, C, can be brought, option D, permissible only in some circumstances. Yes, 41 ka A is the correct answer, Ujjwal Nahar ji. Sorry, Vinny ji. A is the correct answer. That is, if a suit hasn't filed for compensation when filing the suit for a specific performance, then at later stage the suit for compensation is barred. Question number 42. Now this particular question contains certain codes or कूट, जिसको हम हिंदी में बोलते हैं. Question number 41, you want me to explain, Ujjwal Nahar ji? Which question? Question number 41. Now, I'm quickly explaining question number 41 to you people. The question is saying, like, if you will simply read section 39 or section 40 of Specific Relief Act, it is simply stating damages in lieu of or in addition to specific performance. So what does it mean? It is simply saying that suppose I filed a case against Z for the specific performance, right? And if that suit for specific performance has like collapsed, or the court hasn't allowed me for the specific performance, then at the later stage on the same subject matter, I cannot go into the court again claiming for compensation. Rather than under section 40 of Specific Relief Act, it is a window available to me that any time, at any point of time where I feel that I am not getting specific performance, I can amend my pleadings, I can amend my plaint, and I can make the addition that I want to claim compensation also along with the specific performance. In that case, in that particular suit only, I can claim specific, in that particular suit of specific performance, I can claim for compensation, not a separate suit for compensation. I hope it is clear to you, Ujjwal ji. Now, question number 42. Consider following facts regarding effect of declaration made under section 34 of Specific Relief Act. Option 1, declaration is binding on the parties to the suit and the persons claiming through them respectively. Second point is stating declaration binds all those persons who have knowledge of the suit and knowingly they do not become the party. Option A, only one is correct. Option B, two is correct. Option C, both. First and second is correct, and option D, both first and second are wrong. Question number 42. What should be the correct answer? Option A, only first is correct. Option B, only second is correct. Option C, both first and second is correct. And option D, both first and second are wrong. What should be the correct answer? Question number 42. Yes, this is the direct question from section 34. Direct question from section 34. Yes, 42 ka Vinny ji, you are correct. A is the right answer. That is, in the cases where a declaratory decree has been issued, then only the parties to the suit or their trustee or their representative, against them only that particular declaration is binding, not on all other parties. Question number 43. An injunction cannot be granted. Ankita Gupta ji, C42. No, Ankita ji, 42 ka A is the correct answer, not C. Right? Question number 43. An injunction cannot be granted. Option A, to restrain any person from prosecuting a judicial proceeding pending at the institution of the suit in which injunction is sought unless restraint is necessary to prevent a multiplicity of proceeding. Option B, to restrain any person from instituting or prosecuting any proceeding in a court not subordinate to that from which the injunction is sought. Option C, restrain any person from applying to any legislative body. Option D, all of these. Yeah, all of the above. Question number 43. Question number 43 is again related with your particular section 41 of your Specific Relief Act, right? So if you will read section 41, which is stating that in what cases the injunction cannot be granted. So yes, D is the correct answer for this, right? In all these cases, injunction cannot be granted. Yes, Ujjwal Nahar ji, Vinny ji, both of you are correct. Question number 44. Again from Specific Relief Act, plaintiff without having any title filed a suit for permanent injunction against dispossession based on long possession. This particular question is from section 6 of Specific Relief Act. So plaintiff without having any title filed a suit for permanent injunction against dispossession based on long possession. Option A, because there is no title, plaintiff may be dispossessed. Option B, law respects possession, plaintiff cannot be dispossessed except in accordance with law. Option C, suit is not maintainable. Option D, suit is not maintainable only for the relief of permanent injunction. Question number 44. This particular question is focusing on the ideology of section 6. So this particular question's answer is not available in the Bare Act, but if you will read some of the book or case commentaries, you will be in the position to answer. Yes, 44 ka B is the correct answer. Yes, Vinny ji, you are right that the law respect the possession and plaintiff cannot be dispossessed except in accordance with law. Question number 45. An injunction can be granted. Now you have to see. Question number 43 was stating injunction cannot be granted. Question number 45 is stating injunction can be granted to prevent on the ground of nuisance an act of which it is not reasonably clear that it will be a nuisance. Option B, to prevent a continuing breach in which plaintiff has acquiescence. Option C, to restrain the wrongfully sale of any property in dispute in a suit in execution of decree. And option D, to prevent the breach of a contract, the performance of which would not be specifically enforced. Question number 45. What should be the correct answer? An injunction can be granted. In which of the following cases the injunction can be granted? Yes, just let me know. Question number 45. Its correct answer is C. Yes, Vinny ji, you are again correct. Its correct answer will be C. Right? Now, next question is question number 46. That is, specific relief may be granted. Option A, for enforcing individual civil right. Option B, for enforcing a penal law. Option C, for enforcing both civil and a penal law. ऑप्शन डी फॉर एनफोर्सिंग पब्लिक राइट्स। क्वेश्चन नंबर 45 का सी, यस उज्जवल नाहर जी, 45 का सी इज द करेक्ट आंसर। 46, specific relief may be granted for enforcing individual civil rights, for enforcing a penal law, for enforcing both civil law and a penal law, and for enforcing public right. Yes, Vinny ji, Ujjwal Nahar ji, both of you are correct. Its correct answer will be A. Next, question number 47. Now, this question is from Limitation Act. The period of limitation for a suit to compensation for a malicious prosecution is option A 90 days, option B 6 months, option C 1 year, and option D 3 years. What should be the correct answer for 47? A suit for compensation for a malicious prosecution can be filed within 90 days, 6 months, 1 year, and 3 years. Question number 47. What should be the correct answer? Yes, C is the correct answer. Vinny ji, you are correct. Its correct answer will be C, that is 1 year. If you will read Schedule 1, Article 74. Schedule 1, Article 74 is stating the period of limitation for suit in the case of malicious prosecution. The period is of 1 year. Question number 48. Section 5 of Limitation Act 1963 does not apply to. Section 5 of Limitation Act 1963 does not apply to. Option A, suit. Option B, execution petition under Order 21 of CPC. Option C, petition for divorce under Hindu Marriage Act 1956. And option D, all of these. Yeah, all of the above. Question number 48. What should be the correct answer? Section 5 is talking about which things? Yes. Can anyone tell me? 48, what should be the correct answer? Quite easy question. Its correct answer will be your option D for Delhi. That is all of these. Now, as per Section 5, application can be filed under Section 5. No, Ujjwal Nahar ji, D is the correct answer. Sir, we should remember. No, you don't have to remember all the article numbers, Vinny ji, only the important article numbers. Now, what I will do, I will just share the important article numbers like in tomorrow's session, right? So that will give you a clear idea. Now, Section 5 is simply stating, Section 5 of Limitation Act is simply stating that an application can be filed in the cases of appeal and application other than application for execution of decree. And execution of decree is given under Order 21 of CPC. So accept the application for Order 21 of CPC and suit. In all other cases, like in the case of appeal, the general application can be entertained under Section 5. Question number 49. The period of limitation for preferring an appeal from a decree passed by the court to the subordinate to the High Court to a High Court from the date of the decree is option A 90 days, option B 60 days, option C 30 days, and option D 1 year. Question number 49. Its correct answer is yes, 90 days. Again, Vinny ji, you are correct. I think today Vinny ji is in form. She is performing quite well. Question number 50. Section 5. Again, a question from Section 5. Section 5 of Limitation Act 1963 applies to suits, appeals, executions, all these. Section 5 of Limitation Act applies to suits, appeals, applications, and executions, and all of these. Question number 50. What should be the correct answer? Section 5 of Limitation Act 1963 applies to suits, appeals, executions, and all of these. What should be the correct answer? Section 5 of Limitation Act. It applies only to option B. Bangalore is the correct answer, because it only applies to suit and applications, but not the applications for execution. So C cannot be the answer. Suits पे तो application वैसे ही नहीं है, so A cannot be the answer. So we are left only with option B. No, Ujjwal Nahar ji, 50 का correct answer will be B. I will suggest you all remember Section 5, 6 of Limitation Act. बहुत अच्छे से पढ़ के जाइए, इनसे हर बार क्वेश्चन बनता है, स्पेशली सेक्शन 5 से. ठीक है, सेक्शन 4, 5, सेक्शन 13, then योर सेक्शन 25, सेक्शन 27, इनसे क्वेश्चन बनते हैं लिमिटेशन एक्ट में. Next question, question number 51. This question is from MP Accommodation Control Act, right? Which one of the following option is correct regarding notice of increase of area of rent? Which of the following option is correct? So they are asking ki which of the option is correct regarding notice of increase of area of rent. First point, notice must be given orally or in writing by landlord or on behalf of landlord. Second point is stating notice may be given to the tenant personally or to one of his adult member of family or to his servant. Option A, first is wrong and second is right. Option B, second is right and first is wrong. Option C, both first and second both are right. And D, both first and second both are wrong. What should be the correct answer? Yes, question number 51. Question number 51. Okay, so you are saying that both are right, Ujjwal Naharji. Now this particular question was in dispute in MP High Court and finally they considered both option A and B as correct. And let me tell you, यहाँ पे slight error कहाँ पे हुआ था? There was a slight error if they would not have mentioned this word. If they would not have mentioned this word, then probably its correct answer could have been C. But as of now, what they have done, they have mentioned both. So in both of the cases, there is a flaw. So both of these options have been considered correct. Question number 52, MP Accommodation Control Act. A revision against a final order passed by the Rent Controlling Authority on an application submitted by the retired government servant for the eviction of his tenant on the ground of bona fide requirement shall be to a. Yes, Ujjwal ji, Ankita ji, you people can say that 51 ka C can be the correct answer. So options are A, to the High Court, option B, to the Court of District Judge, option C, the Civil Court, and option D, the Commissioner. 52, what should be the correct answer? If you will read section 23, A, B, C, D, E, F, G, H, I, J and all. So there you will get the answer. 52 ka yes, A is the correct answer as per section 52 F, right? A is the correct answer. Rohit Gautam ji, you are correct. Vinny ji, you are also correct. Now, next. Question number 53. MP Accommodation Control Act, member of family does not include. MP Accommodation Control Act, member of family does not include. Option A, spouse. Option B, unmarried daughter. Option C, unmarried sister. And option D, married daughter. Which of the following does not included as a member of family? Spouse, unmarried daughter, unmarried sister, and married daughter. Yes, Ankita Gupta ji, 52 ka B is not the correct answer, A is the correct answer. Yes, Ujjwal ji, Vinny ji, Rohit ji, all of you are correct. Married daughter is not considered as a member of family. Question number 54. MP Accommodation Control Act. After a notice of demand for area of rent has been served on tenant, he should pay or tender the area of rent to save himself from eviction. Option A, within 15 days. Option B, within 1 month. Option B, within 2 months. Option D, within 3 months. Question number 53, D. Yes, Ankita ji, you are correct. Question number 54. Yes, within 15 days, within 1 month, within 2 months, within 3 months. So if a tenant want to save himself from eviction, he has to make the area of payment of rent within how many days of demand of area of payment by the landlord. Yes, 54. 54 ka what should be the correct answer? Yes, C is the correct answer. That is within 2 months, right? Nahi Ujjwal Nahar ji, 54 ka D nahi hoga. Its correct answer will be C. Yes, Rohit Gautam ji is correct. Vinny ji, A bhi nahi hoga. Next question, 55. Under the which provision of MP Accommodation Control Act 1961, penalties can be imposed by the landlord and penalties can be imposed on the tenant and landlord. Okay. Under which section of MP Accommodation Control Act penalties can be imposed on the landlord and tenant? Options are 42, 43, 44 and 45. What should be the correct answer? Penalties can be imposed on landlord and tenant. 55 ka yes, B is the correct answer. Vinny ji, Rohit ji, both of you are correct. Question number 56, that is from MP Land Revenue Code. Who would decide the dispute regarding boundaries between villages, survey numbers and plot numbers? Who would decide the disputes regarding boundaries between villages, survey numbers and plot numbers? Option A, collector. Option B, SDO, that is subdivisional officer. Option C, revenue inspector. And option D, tehsildar. So who is going to decide the dispute regarding boundaries between villages, survey numbers and plot numbers? 56. What should be the correct answer? Yes. If you will read section 125 of MP Land Revenue Code 1959, you will get the answer. Its correct answer is D. Yes, Rohit ji, you are correct. Its correct answer is tehsildar. No, Ujwal Nahar ji, it is not SDO, it's tehsildar. Question number 57. Where a Bhumi Swami has been dispossessed unauthorizedly, he will make an application for restitution of possession under section 250 of MP LRC before. Option A, tehsildar. Option B, Hardik Vyas. 56. Yes, Hardik Vyas, 56 ka D is the correct answer. 57. Where a Bhumi Swami has been dispossessed. Vinny ji, it will not be A. It will be D. Ankita Gupta ji, yes, D is the correct answer. So where a Bhumi Swami has been dispossessed unauthorized, he can make an application for restitution of possession under section 250 of MP LRC before. Tehsildar, SDO, collector and revenue inspector. Yes, its correct answer is again tehsildar. So 57 ka again is the correct answer. Question number 58. MP Land Revenue Code. An application by the party interested will be presented to the tehsildar for demarcation. No, Ujwal Nahar ji, its correct answer will be A, right? An application by the party interested will be presented to tehsildar for demarcation of boundary of a survey number or a subdivision or of a plot number and construction of boundaries and marks thereon. Option A, under section 124, under section 129, under section 127, under section 125 of MP LRC. What should be the correct answer? MP Land Revenue Code के which provision, किस provision के अंदर तहसीलदार के सामने demarcation of boundaries and survey and plot numbers के लिए and the construction of boundary marks के लिए application डालती है party? ठीक है? So its correct answer will be B for Bangalore, that is under section 129. Nahi Rohit ji, its correct answer will be option B, that is under section 129, not under section 125. Question number 59. The offense under section 250B of MP LRC is, and the offense under section 250B of MP LRC is option A, non-cognizable and bailable. Option B, cognizable and non-bailable. Option C, cognizable and bailable. Option D, non-cognizable and non-bailable. So an offense under section 59, an offense under section 250 subclause B of MP LRC, the offenses are of which nature, right? The offenses are of which nature? They are cognizable and non-bailable. They are cognizable and non-bailable. Under section 250 clause B, the offenses committed are cognizable and non-bailable. So B for Bangalore is the correct answer for this question. Question number 60. Bit lengthy question. Read it calmly before you answer, right? Under MP LRC 1959, which of the following matter is not in exclusive jurisdiction of revenue authority? Option A, any claim to modify a decision determining abadi made. Rohit Gautam ji, Ankita ji, 59 ka correct answer will not be C. Its correct answer will be B for Bangalore. That is cognizable and non-bailable, right? Question number 60. Under MPLRC 1959, which of the following matter is not in the exclusive jurisdiction of Revenue Authority? Option A, any claim to modify a decision determining abadi made by a settlement officer or collector. Option B, the amount of land revenue assessed or reassessed under this code or any other enactment for the time being in force. Option C, any claim against the state government to have any entry made in any land records or to have any such entry omitted or amended. Option D, any dispute in which state government is not a party relating to any right which is recorded in the records of right. Yes, what should be the correct answer? Question number 60. Any claim against the state government to have any entry made in any land records or to have any such entry omitted or amended. Option D, it is stating any dispute to which the state government is not a party relating to any right which is recorded by the records of right. So its correct answer will be D. If you will read section 111, section 111 of MPLRC 1959, MP Land Revenue Code 1959, you will get a clear answer of this question, that any dispute to which state government is not a party relating to any right which is recorded in the rights of record shall not be dealt by the revenue authority. That particular matter has to be dealt by the other court, civil court. So its correct answer will be D. So that is it for the day. Anyone having any confusion in whatever questions we have discussed? If you people are having any doubt, you want me to discuss any question specifically, yes, Ankita Gupta ji, 60 ka D is the correct answer. So if any one of you are having any doubt or confusion, or you want me to discuss any particular question in detail, just let me know, or else we can meet up tomorrow with some fresh discussion of Indian Evidence Act, some of the questions of IPC. So tomorrow we are going to take up Indian Evidence Act and IPC of 2018 shift 1 question paper, right? And apart from this thing, there's a very humble request. When you people attend the session and when you actually like it, you find it informative for you, don't forget to press the like button and don't forget to subscribe to our channel, right? No sir, it's clear. Thank you. Thanks a lot. Thanks a lot to all of you. So don't forget to like the video and to subscribe to the channel. And if you people haven't enrolled for MP Civil Judge Prelims Crash Course, just do check it out. Link is in the description box. I'm repeating again, this particular crash course and especially these 10 mocks are going to create wonders for you. These 10 mocks are going to create wonders for you for sure. So do check it out, right? Milte hain in the next class with some fresh discussions and with some fresh knowledge. Thank you, Ujjwal ji, Ankita ji, Bini ji. Thanks to all of you. See you all tomorrow.